Today, the hidden algorithms ruling our lives. Hello again, it's Martin North from Digital Finance Analytics. Welcome to the latest post covering finance and property news with a distinctively Australian flavour. This is a show about algorithms and who controls them. An algorithm is a set of instructions designed to perform a specific task. This can be a simple process such as multiplying two numbers together, or a complex operation relying on complex sets of rules and data. In fact, you may be watching this show thanks to YouTube's algorithm flagging it as a recommended view for you. But algorithms are everywhere. Loan applications will be vetted by an algorithm. Relationship matching services use them, as do police and security agencies, traffic management systems, and even in the defence sphere. They are simply everywhere, and some are now endowed with a level of artificial intelligence and machine learning, making the algorithms perhaps smarter and certainly more autonomous. But the question I've got for you is, who watches the algos? Frankly, I'm getting more concerned about how algorithms are taking over, and how governments and institutions can seemingly avoid accountability for the decisions these rules make. This is true from the ATO to Centrelink. Robodebt is one good Australian example, which has had terrible social consequences for people. At the heart of that case was an income averaging algorithm, and at least 4,000 debts a year were calculated with averaged income data from 2007 onwards. While the government claimed that computing systems introduced from 2015 to automate income averaging meant that the government knows who every single one of those individuals are, prior to that there was no computing system that existed. The government also said that governments have calculated debts partially or solely based on income averaging for 20 to 30 years, and done so en masse since 2007, including an estimated 16.6% of debts in 2009 and 24.4% in 2011. Now, a month back, the government reached a settlement with Gordon Legal, a law firm running a class action on behalf of hundreds of thousands of people caught up in the coalition's government welfare debt recovery program. The settlement was for an eye-watering $1.2 billion, but almost all of the money came from the government's May announcement to repay and wipe debts raised using the unlawful income averaging of ATO pay data. In fact, the only new figure was $111 million in compensation that will be shared between around 430,000 victims. The sum will vary significantly depending on how much debt people had paid and how long they'd been without their money. Legal costs, which will be deducted from the compensation, are yet to be determined. Now, many people have flooded victims' groups' Facebook pages, as well as Gordon Legal's own page, to express frustration at the compensation figure, which they feel does not reflect the pain or suffering the 4-year program caused. Moreover, some are angry that a scandal they see as being punctuated by continual cover-up and obfuscation never made it to a courtroom. Gordon Legal emphasised the settlement as an excellent outcome for clients and group members, and it should be viewed in its full context. When you think about the totality of what's been achieved since the proceedings were commenced, that really amounts to more than $1.2 billion, said a partner at the law firm. It was a case actually brought by Victorian Legal Aid that established the legal precedent that ruled that Robodebt's income averaging was unlawful. But in the months afterwards, the government simply stonewalled. It said nothing about refunds and claimed only a small cohort of people had been affected. Indeed, the refund decision in May was prompted by the need for a strategy to respond to the Gordon legal class action. And the $111 million figure was said from the government's perspective to represent the interest owed rather than compensation for stress or anguish. The Government Services Minister Stuart Robert later publicly confirmed the government's view of the compensation, noting it was for the most part for interest payments for money held. And the Commonwealth has not accepted or admitted any liability in the matter, Robert noted. Though victims longed for their day in court, the 2-week trial promised to be a fairly dry affair, based mainly on documentary evidence and legal arguments. The government did not plan to call any witnesses, so there was little prospect the former Human Services Minister Alan Tudge or top departmental officials would need to take the stand. In addition, the government's prospects advice from earlier in the year said while it was likely a court would order refunds plus interest, Gordon Legal's negligence claims was unlikely to succeed. Still, for some victims, the government's lawyers would have been there in the virtual courtroom defending their case. Gordon Legal's statement of claim, for example, alleged Centrelink was well aware of the distress the programme had caused victims. Perhaps as many as 100,000 people were also left out of the refunds because they provided payslips or bank statements after being hit with an initially unlawful debt. And it was then recalculated and a debt was substantiated. And Gordon Legal, which had initially argued these debts were tainted, dropped that claim in the settlement. Some of these people expressed anger and confusion at the outcome in conversations with The Guardian Australia recently. Other refund recipients, like the man who told The Guardian his debt had been a factor in his marriage breakdown, may only get the sense of justice they seek from a royal commission as proposed by Labour and the Greens. Now, with the settlement, it does feel like everything's gone back to normal. They've made penance and everything goes good again. Whereas I think a lot of us are still dealing with the impacts of what they did years ago, even if we got our refunds, said one person who'd been impacted. But this is a good example of how algorithms drive a series of outcomes and consequences for real people. And at the end of the day, that algorithm was never really tested in court. And there could be a coming war on the hidden algorithms that trap people in poverty. This is according to a recent MIT article which said that a growing group of lawyers are uncovering, navigating and fighting the automated systems that deny the poor housing, jobs and basic services. Credit scores have been used for decades to assess consumer creditworthiness, but their scope is far greater now that they are powered by algorithms. Not only do they consider vastly more data in both volume and type, but they increasingly affect whether you can buy a car, rent an apartment, or even get a full-time job. Their comprehensive influence means that if your score is ruined, it can be nearly impossible to recover. Worse, the algorithms are owned by private companies that don't divulge how they come to their decisions. Victims can be sent in a downward spiral that sometimes ends in homelessness or a return to their abuser. Credit scoring algorithms are not the only ones that affect people's economic well-being and access to basic services. Algorithms now decide which children enter foster care, which patients receive medical care, which families get access to stable housing. Those of us with means can pass our lives unaware of any of this, but for low-income individuals, the rapid growth and adoption of automated decision-making systems have created a hidden web of interlocking traps. But fortunately, a growing group of civil lawyers are beginning to organise around this issue, borrowing a playbook from the criminal defence world's pushback against risk assessment algorithms. They're seeking to educate themselves on these systems, build a community and develop litigation strategies. Basically, every civil lawyer is starting to deal with this stuff because all of our clients are in some way or other being touched by these systems, says Michelle Gilman, a clinical law professor at the University of Baltimore. We need to wake up, get training. If we want to be really good holistic lawyers, we need to be aware of that. Am I going to cross-examine an algorithm? Well, Gilman has been practicing law in Baltimore for 20 years. In her work as a civil lawyer and a poverty lawyer, her cases have always come down to the same things, representing people who've lost access to basic needs like housing, food, education, work, or healthcare. Sometimes that means facing off with a government agency. Other times it was a credit reporting agency or a landlord. Increasingly, though, the fight over a client's eligibility now involves some form of algorithm. This is happening across the board to our clients, she said. They are enmeshed in so many different algorithms that are barring them from basic services, and the clients may not be aware of that because a lot of these systems are invisible. For low-income individuals, one temporary economic hardship can lead to a vicious cycle that sometimes ends in bankruptcy or homelessness. She doesn't exactly remember when she realised that some eligibility decisions were being made by algorithms, but when that transition first started happening, it was rarely obvious. Once, she was representing an elderly disabled client who had inexplicitly been cut off from her Medicaid-funded home health care assistance. We couldn't find out why, Gilman remembers. She was getting sicker, and normally if you get sicker, you get more hours, not less. Not until they were standing in the courtroom in the middle of a hearing did the witness representing the state reveal that the government had just adopted a new algorithm. The witness, a nurse, couldn't explain anything about it. Of course, they bought it off the shelf, Gilman said. She's a nurse, not a computer scientist. She couldn't answer what factors go into it, how it was weighted, what are the outcomes that you're looking for. So there I am with my student attorney who's in my clinic with me, and it's like, oh, I'm going to cross-examine an algorithm? For Kevin DeLemon, an attorney at Legal Aid in Arkansas, the change was equally insidious. In 2014, his state also instituted a new system for distributing Medicaid-funded in-home assistance, cutting off a whole host of people who had previously been eligible. At the time, he and his colleagues couldn't identify the root problem. They only knew that something was different. We could recognise that there was a change in assessment systems from a 20-question paper questionnaire to a 283-question electronic questionnaire, he says. It was 2 years later, when an error in the algorithm once again brought it under legal scrutiny, that DeLemon finally got to the bottom of the issue. He realised that nurses were telling patients, well, the computer did it. It's not me. That's what tipped us off, he said. If I had known what I knew in 2016, I would have probably done a better job advocating in 2014, he adds. One person walks through so many systems on a day-to-day basis. Gilman has since grown a lot more savvy. From her vantage point representing clients with a range of issues, she observed the rise and collision of two algorithmic webs. The first consists of credit reporting algorithms, which affect access to private goods and services like cars, homes, and employment. The second encompasses algorithms adopted by government agencies, which affect access to public benefits like healthcare, unemployment, and child support services. On the credit reporting side, the growth of algorithms has been driven by the proliferation of data, which is easier than ever to collect and share. Credit reports aren't new, but these days their footprint is far more expansive. Consumer reporting agencies included credit bureaus, tenant screening companies, or check verification services amass this information from a wide range of sources: public records, social media, web browsing, banking activity, application use, and more. The algorithms then assign people worthiness scores, which figure heavily into background checks performed by lenders, employers, landlords, and even schools. Government agencies, on the other hand, are driven to adopt algorithms when they want to modernise their systems. The push to adopt web-based apps and digital tools began in the early 2000s and has continued with a move towards more data-driven automated systems and AI. There are good reasons to seek these changes. During the pandemic, many unemployment benefit systems struggled to handle the massive volume of new requests, leading to significant delays. Modernising these legacy systems promises faster and more reliable results, but the software procurement process is rarely transparent and thus lacks accountability. Public agencies often buy automated decision-making tools directly from private vendors. The result is that when systems go awry, the individuals affected and their lawyers are left in the dark. They don't advertise it anywhere, says Julia Simon-Michel, an attorney at Philadelphia Legal Assistance. It's often not written into any sort of policy guides or policy manuals. We're at a disadvantage. The lack of public vetting also makes the systems more prone to error. One of the most egregious malfunctions happened in Michigan in 2013. After a big effort to automate the state's unemployment benefits system, the algorithm incorrectly flagged over 34,000 people for fraud. It caused a massive loss of benefits, Simon-Michel said. There were bankruptcies, there were unfortunately suicides. It was a whole mess. Gilman worries that coronavirus-related debts and evictions will get codified into credit scores, making it permanently harder for people to get jobs, apartments, and loans. And low-income individuals bear the brunt of the shift towards algorithms. They are the people most vulnerable to temporary economic hardship that gets codified into consumer reports and the ones who need and seek public benefits. Over the years, Gilman has seen more and more cases where clients risk entering a vicious cycle. One person walks through so many systems on a day-to-day basis, she says, I mean, we all do, but the consequences of it are much more harsh for poor people and minorities. And she brings up a current case in her clinic as an example. A family member lost work because of the pandemic and was denied unemployment benefits because of an automated system failure. The family then fell behind on rent payments, which led to their landlord to sue them for eviction. While the eviction won't be legal because of the CDC's moratorium, the lawsuit will still be logged in public records. Those records could then feed into tenant screening algorithms, which could make it harder for the family to find stable housing in the future. Their failure to pay rent and utilities could also be a ding on their credit score, which once again has repercussions. If they're trying to set up cell phone services or take out a loan or buy a car or apply for a job, it's just those cascading ripple effects, Gilman says. Every case is going to turn into an algorithm case. And in September, Gilman, who is currently a faculty fellow at the Data and Society Research Institute, released a report documenting all the various algorithms that poverty lawyers might encounter. Called Poverty Logarithms, it's meant to be a guide for her colleagues in the field, divided into specific practice areas like consumer law, family law, housing and public benefits. It explains how to deal with issues raised by algorithms and other data-driven technologies within the scope of existing laws. If a client is denied an apartment because of a poor credit score, for example, the report recommends that a lawyer first check whether the data being fed into the scoring system is accurate. Under the Fair Credit Reporting Act in the US, reporting agencies are required to ensure the validity of their information, but this doesn't always happen. Disputing any faulty claim could help restore the client's credit and thus access to housing. The report acknowledges, however, that existing laws can only go so far. There are still regulatory gaps to fill. Gilman hopes the report will be a wake-up call. Many of her colleagues still don't realise any of this is going on, and they aren't able to ask the right questions to uncover the algorithms. Those who are aware of the problem are scattered around the US, learning about navigating and fighting these systems in isolation. She sees an opportunity to connect them and create a broader community of people who can help one another. We all need more training, more knowledge, not just in the law, but in these systems. She says, ultimately, it's like every case is going to turn into an algorithm case. In the long run, she looks to the criminal legal world for inspiration. Criminal lawyers have been ahead of the curve, she says, in organising as a community and pushing back against risk assessment algorithms that determine sentencing. She wants to see civil lawyers do the same thing, create a movement to bring more public scrutiny and regulation to the hidden world of algorithms their clients face. In some cases, it probably should just be shut down because there's no way to make it equitable, she said. And that is really an important message for today. Algorithms are everywhere. They determine what credit you get, they determine what government services you can access, and a bunch of other things too. And yet most of those algorithms are not transparent, not disclosed, and many people working within the various industries and government service areas have no clue as to how they work. And so we seem to be in a world driven by decisions that are in turn driven by algorithms that are driven in turn by rules that are hidden. This is not a good look, and I fear that without a change of attitude, direction, and government policy, this is just going to get worse. But next time you come across a situation where a decision has been taken, it's worth asking whether in fact an algorithm has been involved and whether the algorithm is actually acting on the right data or not. I'm Martin North from Digital Finance Analytics. Many thanks for watching, and I'll see you again next time.